Is a police officer. Now, what happens after this exposure? You've gone into you've done some law, undergrad, postgrad, and even the others do masters. But then what happens? Are they deployed in those particular areas? Because it would be a fallacy if you have someone who has been well grounded in the law, and from there you take him. Sorry, I hope it doesn't apply. But you take him and he's in charge of call it the canine unit. What has happened to his law? What has happened? Are these people influencing policies? Do they know what is taking place? Because there's that sense that you call orders from above. Do we have people? Do we have systems in place? Do they check among themselves to see how they're doing that stuff and how they can improve? Because they have a very critical role they play. Okay, are they alive to these constitutional imperatives? And it will be very unfortunate if you have these people who are supposed to be grounded in the law, and yet they are in total disregard. They have no respect. Is it impunity? Is it excess? Is it, what is it? So I think these are some of the questions we need to be asking our colleagues in those entities, whether they're up to the game, how do they fit into this pipeline? Because I mean, it's a given. You can't run away from that. They are part and parcel of this equation. But what is it that they're doing? All right. And you look at that day for candid conversations, like I think Mr. Alex Resida brought out, okay, affecting their day-to-day running of the operations. The bottom line should always be, do they meet the basic universally accepted standards? You know that they're doing. You talk of arrest. How are you arresting? Because we know it's all given. You have to arrest the wrongdoer. But do you recognize, are you cognizant of the fact that he's entitled to those rights? Are you promoting, encouraging, and obeying, fulfilling the mandate as provided for? Okay? So we need to, I think, focus much on this one. And at the end of the day, like I had occasion to discuss with colleagues, it is one thing to have the law, but is the law being utilized appropriately? Is it being put to good use? Are we breathing? Can we breathe life into the law? Because the law is there, it is good law. But are we breathing? Why do people turn the other side? And you ignore. Mr. Resident talked about the rulings. You are talking of bail, really. Honestly speaking, as a judicial officer, why should it take you ages to come and pronounce yourself on a ruling for bail? You are delaying the system, you are clogging the system. In one or another, you are actually building on the case backlog. So we need to address some of those ones. Of course, I didn't want to bring in any issue to do with Kenya for very obvious reasons. But I want to believe that what is applicable here, I think we share so much other than sharing the Lake Victoria. We have so many cultural and historical ties. And I want to believe what is here is not very different from what our colleagues encounter the other side. So as regards this police to prison pipeline, as I've already pointed out, I want to believe it would be okay because it's part of the system. But the point is, how is it being effected? Okay. And then the citizens get trapped because they expect much. Any ordinary citizen would expect that there's obedience. I mean, there's compliance with the law. They are respecting the law, and someone would have no problem going to the law and proving. I mean, not proving, but having his day in court. So I beg to stop there for now. Thank you very much.
Thank you. So, and thank you for outlining those very key points. But still staying with you, Senior Counsel, before I revert to Senior Leader. ask, when prosecutors act without evidence or send remand necessary, remedies are often weak. So we would like to find out from you what real practical solutions exist to prevent abuse and hold the system accountable. Senior Counsel.
Thank you very much. There was some break. I hope I got you, but if I got you right, as if you're addressing this question of failure by the prosecution, and if they're having issues either with evidence or something, if I got you right, because there was something wrong with, I think, the connectivity.
Yes, Senior Counsel, that's the position. Unfortunately, I'm in a country that restricts Twitter, so sometimes VPN is an issue as well.
Okay, that's sorry about that. Yeah, so now, as we said, the prosecution, if we could say that, have also a pivotal role they play in the criminal justice system. Our constitution provides for this, and I think Article 120, Clause 3, the functions of the DPP, among others, to direct the police to investigate any information of a criminal nature and report to the DPP expeditiously. The prosecutor or the state attorney, for that matter, is obliged to do exactly that, because the policeman will go down to the ground, will investigate and lay firm background of what has happened and report, because that's what we call compile the report, the file, subject it, send it to the state attorney for perusal and advice. So the challenge is going to be, is the state attorney doing what is expected of him? There's what they call prosecution-led investigations, because that is the essence of directing the police. Meaning, the state attorney is under duty, is under an obligation to ensure that he's on top of the game. Chances are he's the one who's even going to prosecute this matter in court. So it would be very unfortunate if this state attorney, instead of using his powers, is abusing the powers. Because it's very possible. You have something and you decide to look the other side. You ignore the obvious. I think my colleague, Mr. Rizid, mentioned, I think, did he say, he gave an example, is it in Chisoro, where he says he hails from? And unfortunately, some of these people, they're marginalized. They don't have. I think it was yesterday's space, Madame Christine Biraba was talking about that. This person has gotten into conflict with the law. The relatives, the kids and kin, the whole village has come up not in arms, have come, they've even done a harambe to raise funds to make sure he's represented, because most of them don't have even the representation. So now the state attorney, some of them, I'm not saying all, you may find an instance where a state attorney decides to look the other side. He abandons what he should be doing and then he elects to do something else. There's that common saying, not common saying, that prayer well stated in Luganda. Things something like that. Instead of doing what they're supposed to be doing, they don't do it. So now it will be very unfortunate if we have such such a state attorney ignoring what he's supposed to be doing and then electing to do something different. That's why at times you hear, it is a common, you hear stories being said that a poor man will never have justice in our system, which is very unfortunate. And the period I've spent in this practice, at times you get those cases. Someone is telling you, counsel, your senior counsel, you know what, I don't know anything about this case. But because at the end of the day, an offense must have been committed by someone. Someone is picked up and is paraded in court, is arraigned in court, okay, after spending so many years behind the cells. And when it comes to hearing, if you ever get to the hearing, the complainant or the person who is supposed to be giving critical evidence is even saying, I don't know this person, I've never seen him. And this is a guy who has spent time. And so you wonder, what was the state attorney really up to? Okay? Was there use of office or abuse of office? So now the practical solution should be, we should encourage public participation. especially if there is reason to believe that the state attorney is not doing what he's supposed to be doing. I think I'm reliably informed the DPP, Office of the DPP or DPP, has opened up complaints desk, which is, I think, a commendable gesture. The wananchi, the accused persons, the complainants, even relatives, lawyers, etc., can write. And the office of the state attorney of the DPP is obliged to look at these concerns and see how best they can be addressed. The other one should be to demystify this myth that justice is for the rich. So it is incumbent upon our colleagues, the state attorneys, to ensure that they do their job. Let justice be seen being done. If someone has complained, now the problem is those of us who have been doing criminal law practice, outside there, people will think they just look at the concerns of the victim, the complainant. But on our part, we're also saying that this accused person is entitled to certain rights, clearly stated. That is why we even have the sanctity of the presumption of innocence. As the prosecutor, you lead your evidence, you assemble your evidence, make sure you have what it takes to prosecute this person, and successfully. But if in the course of time, during the interaction, during the engagement, during your perusal, you really find there's no evidence, why do you insist on prosecuting this person? Okay, I think there should be something when it comes to that. At times you get to the extent where you even have a knowledge being entered because they've run short of, it is okay if you've not laid any evidence and you fail to get the critical or the key witnesses. That is understandable. But you've laid evidence, and along the way, you realize you're hitting a dead end. You're flogging a dead horse. And then you're going for a nolle prosequi. Why shouldn't such a state attorney actually be put book? Okay, why do you insist on prosecuting? I want to borrow or to say something about the ICD. ICD, I think, borrowing from the international jurisprudence, international sin. They have what they call confirmation of charges. Before you send a matter for trial, either before a single judge or a panel of judges, go through the evidence, whatever you've assembled to date, and you think you can ably sustain a prosecution. So that at that level, you decide not to continue with such a trial because it helps, and especially the accused person, and especially in a regime where a legal regime where we don't have compensation. Someone spends 5 years in prison waiting for his day in court. He's waiting for another time if he has been convicted for another 3 years or so before he goes on appeal. And at the end of the day, he's acquitted, the appeal is allowed. What happens? You've really disorganized this fella for all these years he has been. And then the prolonged trial. What happens? It is very likely the prosecution or the state, if it's understandable, if you are short of witnesses are mobile, they are no longer traceable, that is understandable. But if it so appears, so happens that the state attorney is behind the delays, why shouldn't such a person be put to book? Should be put to task. Okay. The other one could also be opposing bail. I've already given you that instance. Someone is sick for all intents and purposes. Everyone can see the fella is sick. Okay. The fella is in need of medication. And there you are, state attorney. You are ably, powerful, and whatever term you want to use, opposing the bail. I think we should really put a face to this. Like Mr. Resident said, whatever it is, you never know. Next time it could be you. So I think wherever we are, we should ensure that we do our role, what is expected of us, especially if you are the other side. You are the prosecutor, you are the investigating officer, you are the police officer. Okay, much is expected of you. Like they say in the Bible, to those who are given much, much is expected from them. These people are wielding power, okay, but they shouldn't be abusing this power. They should be using the power, not abusing the power. So I think we need to draw a line through on that and encourage our colleagues to ensure that they do what is expected of them in full view of the constitutional provisions. Let them breathe life into the Constitution. If you know you have nothing to prove against this accused person, declare so. It's not a given that you must prosecute all cases. It's not a given that you must oppose all bail applications. I think we need to get to a stage where our colleagues do exactly that. And I think our criminal justice system will be counting on them to do that. Thank you.
Thank you so much, Senior Counsel Kunya, for outlining those very pertinent points. Indeed, it's very unfortunate that our colleagues seem adamant to do what's right and do it by the book. And as we speak, we sent an invitation for them to join this X-Space. But unfortunately, as you know, they decided to abstain from this discussion because, of course, they knew that such submissions of intellect by legal juggernauts such as yourself would be coming up. But thank you so much for raising that. But I would like to move this conversation to Mr. Resida, and I know he mentioned this in his earlier submission on oversight mechanisms such as the Police Council and the Inspector General of Police. I would like to ask you, Mr. Resida, what accountability models, regional or international, could inspire reforms that are feasible and effective? Mr. Resida?
Thank you again. This is a very enriching discussion and quite fundamental when it comes to human rights. Everything else pales. Your question is on oversight and mechanisms and so on. I'll get back to one thing before going into the specifics of the oversight at regional, international, national, regional, international. The thing we need to really emphasize, and there are reasons for emphasizing this, is this aspect of personal liability of the individuals responsible for the excesses that are a concern. And there's a whole legal framework for it. I gave an example of a case filed by a colleague, John Kagwa. But the Human Rights Enforcement Act, I believe it is Section 10, specifically provides for liability of individual actors in very specific terms. And that is something we must take advantage of, something we must encourage people to really utilize. Just to dig it up and to read, yes, it is Section 10, subsection 1, the Human Rights Enforcement Act. A public officer who individually or in association with others violates or participates in the violation of a person's rights or freedoms shall be held personally liable for the violation, notwithstanding the state being vicariously liable for his or her actions. This is a big tool. This is an available tool. This is a tool that sends messages to individuals so they don't hide into this state thing. And in doing so, we must also give credit and recognize very significant improvements for those of us who have seen changes over the years. Very significant improvements in the training, in the equipping and facilitating of police and other state organs, DPP's office and their facilitations, with amazing capabilities, even in the ICT sector, in cybercrime, in forensics. all around, all around. The functionality aspects of the Director of Public Prosecutions has improved with all the setbacks we are talking about. And so the question of excesses, which are not policy, the questions of impunity, which is growing, the questions of abuse of office, we need to pin it down to the individuals that perpetuate those excesses. And that's a critical role for the ULS, for us practitioners. We too need a strong ULS to withstand this, a strong ULS to come out and speak, a strong ULS to champion these causes. Because that's what it is, that's what we have. That's what we have. And the current leadership of ULS has had its mark, has had its impact in this direction. Many challenges across the way. Challenges need to be harmonized without losing focus on the gains that we need to build on. The institutional frameworks and so on that we can use to build up on this. Yes, I did talk about Kenya, the Kenya National Police Authority that they have. We've talked about the police standards unit in Uganda. At the regional level, we are keenly aware that many of us have used the East African Court of Justice as a regional body to try and challenge some of the excesses, even at state level, that we seem to see that at a national level, we may not get the redress that is required. Slow as it may be, still, it gives that hope. It gives that drive. It gives that alternative at a regional level. At international level, the International Bar Association and Uganda Law Society actually does participate in ELS in the IBA activities. Has a number of mechanisms, including protection and support of individual practitioners that come in harm's way in human rights work. So the IBA is one of those institutions that can be looked at. It has very supportive mechanisms. I did mention the UN Working Group on Enforcement of Involuntary Disappearances. As I said, they've done a study. That study is well researched. That study has many recommendations that look at a global trend. Let's not think that it's just lawyers in Uganda, Kenya, or East Africa that are facing challenges. The challenges are global. That study has many recommendations. As I did say, it's going to be presented in this month at the 60th session of the UN Human Rights Council. That's something to look out for and pick from. When you pick best practices, you help to enrich the changes you want to champion at the national level. Because, as I said, the key thing is, are we able to suggest changes that lead to improvement? Are we able to talk about them in a manner that is meaningful, in a manner that is demonstrable, purposeful? And that's why they keep emphasizing changes, amendments that meet international standards so that you are clearly able to have measurable definable, clear sanctions, clear procedures, clear processes when you are talking about holding institutions accountable. We have many other watchdogs at a national level. We have the Inspectorate of Government. Again, with whatever challenges there may be, remember, posterity, if you report something coherently, evidence-based, evidence-backed, it becomes difficult to wish away. And that should be one thing we also need to inform ourselves of. Because, when you issue or read the thematic reports on subjects like elections, election violence, and so on, then you get new trends and how to address them. Because things to do with election violence, election challenges keep reoccurring. But what are we doing about them? It's just like, an election cycle passes and everything is forgotten, including the excesses that are witnessed. That's not a good way to go. We need to be careful about media. Media has taken a different trend. Like Mr. Kunya said, everyone now is a journalist, yes, but we still need mainstream media as a check, as a tool, as a voice. Responsible media. And these UN reports, incidentally, will show you the media advisory sessions that have been held previously under these auspices. I think there is one report that examined the 2,190 cases from 36 countries. You looked at non-state actors, reviewed challenges in implementation of the Declaration and Human Rights, and so on. So the alley is big. Living up the challenge goes back to one aspect I raised. Do we have that capacity? As a law firm, what capacity do we have to engage in all these reports, in all these trends, in all these? It's hardly there. But as law society, can we? And again, that goes back to leadership. When you have corrected leadership that brings out these issues, that channels energies to the pain points where it matters, then we'll get somewhere. So we have a whole array from international level, UN, I did say IBA, we have regional bodies, we have national ones. That's where we should be looking at to anchor our efforts, to anchor our contribution. And we have to have a contribution. We have to have a mark as a generation on these challenges that are not getting less, that are getting regional, that are getting global, a trend that we see clearly that has to be stemmed. I stop there and hope we can get into Q&A if we don't have other presentations. Thank you.
All right. Thank you so much, Counsel Senior Advocate Alex Resida. That has been very insightful. We're really grateful for those insights. And indeed, as you've only said it, the Uganda Law Society has so much to do. And we, as has been said by Counsel Kunya, a lot is expected from us because, as it is in the Bible, a lot is given unto us. And therefore, as you say, the leadership has a lot to do But we want to delve into our final question, like you asked before. The questions will come in later. We also want to apologize, of course, on behalf of Madame Odiambo, who we earlier on intimated was about to catch a plane to South Africa and jumped off because of the network on that same plane. We shall really take apologies and ask that we be excused for that unfortunate instance. But Council Kunya, the last question for you, for example, is because you have been so much into this practice and you've seen a lot, like you've explained, and when you talk of dismantling the prison to police to prison pipeline being urgent, should we prioritize bail reform, the aspects of bail reform, mandatory judicial review of prosecutorial decisions, or alternative dispute resolution? How do these reforms reach the most affected communities? I hope you could hear me. If it's okay, please proceed.
Thank you, most perpendicular Robert. Well, the question talks about reform. And like you always know, we've already experienced wherever we are, that nothing seems to be cast in stone. There's room to improve. And especially if you want to establish an enabling institution or a system, you should always have room to adjust, to reform, to change. It may not be good to dismantle, to do away, but probably to make good what is there. And unless something has outlived its usefulness, that's when you'll think of really dismantling it. So going to that one, I would want to believe that we need, first of all, to accept that things cannot be done as it was in the past, is now, and ever shall be, world without end. No, things don't work like that. There's room to improve. At least if you cannot break, you fix. Okay, so you could fix, you could change, you could see room until such a time that you really feel you can completely do with. So when you talk about the PPP, the police prison pipeline, okay, as I said at the beginning, it's just, I don't want to call it a game changer, but it is something which is part and parcel of the criminal justice system. People will be arrested, people will be handled by the police, they'll be passed on to the prison, as basic as that. But the point is the police doing its bit? Is the prison entity doing its bit? I didn't say much about the prison because there seems to be just basically to keep these people, to keep our clients. Okay, fine, they keep them probably in good terms. They will try to change. They've been offering remedial classes to them. In some places, they are called, I think, correction centers or something like that. You go to Luzira, especially, the guys, the other day, I was presenting someone. When he was being released, he said, I came to Luzira during our days, we used to say, Twaja Tulimbuzi. He had stopped in P4. But the fellow went and resumed adult education, or did his PLE, did his O-level, did even his A-level, even got a certificate from, I think, MOOBS. MOOBS has some venture they're handling with the Luzira. So there are some aspects with prison which they're doing. But one thing I find with them is poor record keeping. You cannot be in charge of, call them 1,500 inmates, and you don't know what is happening. You are keeping people who have not been in the court system, who have been in the court system for 10 years without anything. The other day, I bumped into the Honorable DCJ, and they were doing, some 1 or 2 years ago, they were doing physical count on the files. And he said they go to some court, and the fella had been in court for 20 years, 30 years, something like that. In this modern age and era, with IT, with computers, name it, with so many IT students, IT graduates, some of them even, I think even prison actually has an IT department or directorate for that matter. Why is it that they cannot fix some of this? Okay, so as the prison, at least that is one thing I would imagine they should be looking at. You go to court and you are going to pursue an appeal, and the fella died donkey years ago, 5 years. That's why, but they even don't have the death certificate. And of course, the courts, the justices of appeal will insist, where's the proof that this fella died? So you'd expect that, among other things, the prison authorities should style up their game, okay? Be able to keep records. Fine, they're trying to keep these people, they're equipping them, they're skilling them, but record keeping is still wanting. You are going to present someone in a session and they say, we don't know where this fella is. You know, they have that practice or that tendency of, is it transferring or shifting them from one facility to another? They said the last record we have, the guy was in Chitalia. And then Chitalia has no track. You'd expect that all these, call them small facilities, those upcountry holding facilities, and whatever it is, they should be filling into either the human resource at head office, and at click of a button, someone should be able to know. We have this inmate XYZ. He spent 2 years in Luzira, 3 years in Jinja. He went to Morokutepe, whichever prison it is, and then you know. But it is mind-boggling that you go to court and there you are. There is no record. They even returned actually a record of, we don't know where this person is. So now you wonder, is he dead? What happened? What became of this fella? And yet if you go to prison, you've gone to interact with those people and you find them, I don't know what they call it, but technically they're counting the prisoners because at all times they want to know how many there are, such that they know people who are in prison, who are in the cells, people who are working on the farm, if any, people who are in the sick bay, people who have gone to court. At all times they should know, and they should have a head count which turns a positive result. Short of that, they will not until they've established. So now, why don't they take it further and ensure that you know where these people are? Because if you don't do that, then it's wrong. Of course, I've read so much about the police, our colleagues, the police officers. In the investigations, the searches, are they doing what they're supposed to be doing? What has to be improved? Like I had said earlier on, alluded to, do they do their job the way it's supposed to be done? Good enough, the Constitution provides for the way they do their business. Or the other problem could be the Parliament. Is the Parliament doing its duty also? Is it oversight responsibility? Because the Constitution is very clear. They say they're empowered to periodically regulate how these entities run. Are they doing that? I think it would be just a given that these institutions, occasionally or periodically, they have an honest and candid assessment of how they're doing their work. Involve the stakeholders. Are they satisfied with how they're doing their work? Or if not, let them eat humble pie and adjust accordingly. If not, then other people should be able to tell them what is happening. You would be surprised that I think the rules in the prison are that once someone has been cleared, he has served out his custodial sentence, the rules are that he shouldn't come back. Is it within 6 months or something? I don't know what justification it is. But on the other hand, I think these are people who would be able to tell them what they went through and how they can handle business. I will share with you something brief. I go to visit one of these facilities and I find they've had their own rules. Like I said, they have amri ni amri, order from above. We go, we register like you're supposed to be doing. And when it is time to go into the facility, they say, hey, senior counsel, we are sorry, you cannot go in because you don't said why. What's the problem? You don't have a mask. I said, mask for what? Because that is what the rules say. I said, but I've spent 30 minutes with you here. And none of us is putting on a mask. So now what is it? What are you protecting really? Okay. I've already spent, if I've been affected, I think there was some flu which had come in long after COVID, about a year ago. Good enough, I talked to the OC because I had the person's number. I said, OC, what is this going on? I came here I wanted to go and see my clients. I spent 30 minutes there registering and all that. And when I'm going in, they said, no, you cannot go until you got yourself a mask. I said, no, paying 1,000 wouldn't be a problem, but what are you really preventing? Good enough. He said, no, I'm going to investigate. He went and said, no, actually what you did is true. There's no one putting on a mask. So this question of order from above, I'm not saying that people should be rioting, but I think it should be given a new dimension. As I said, what is this policy? Because you have so many people coming in, young people probably, I would say. Probably they are more exposed, but are they given an opportunity? Can they air out their concerns? Because they know how the system operates. I said people have been released. They've been in prison for some years or some time. They know what it is, what it means. Can they be given opportunity to come and share with them? They say, I spent so many years with you. This is what I observed. If you could do this, probably could be changing, among other things. One other thing could be, those of you who have been to Israel, for instance, the rules are very clear. They want you to register, whether you've been there on Monday, whether you've gone Tuesday, every day you go there, as if they've never seen you. Senior counsel, we know you, but where's your ID? You don't have an ID, please, you go back. I said, but you can. I was here yesterday. I said, no, that was yesterday. Today, Amri, you bring the ID. I went to one first and the fella had the audacity to ask me, among other things, okay, we've seen your letter, we've seen your ID. Where's the PC? I said, what are you talking about? I'm senior counsel, my friend. No one has ever asked me for a PC, even in the court. Now here I am in a prison and they're asking me for a PC? Really? What is the relevance? I mean, if there are quacks who are coming in, that's a different matter. But we should really try to move out from some of those ones. So the PPP could be there, but if there are gaps like they're supposed to be, there should be room for periodical review, those stakeholder engagements, candid talk, and then we build from there. And then, because some of them still remain relevant to the legal system, you cannot run away from the prison, you cannot run away from the police. They have a role they play, but how are they doing? We can improve on the way they are doing their things, and they should be alive to those changes or the proposals. And then the other thing could be they could also realign, do reshape. As I said, you breathe life into what you're doing. You know the law. The law empowers you to do certain things. Why don't you observe the law? Why don't you respect the law? Why don't you uphold the law? You are supposed to be enforcing the law, but you are the same people who are in breach of the same law you're supposed to be promoting and upholding. Same story I've talked about those arrests. Why do you arrest then you start investigating? You arrest and then it takes you ages. You're still gathering evidence. Why don't you put the law to good use? And the entitlement, I think Article 28, Clause 1 is very clear. A right to a fair hearing, including, among others, speedy trial before a competent, independent, and a competent court. Okay, impartial court. Speedy trial. If you are really foot dragging, why should this accused person still keep on coming to court? And worse still, you cannot even release him on bail. And yet there you are, still gathering evidence. Like I said, you build your case, then go and arrest. Good enough, they've been talking about those issues. I don't know when they will implement them, but I think that is where we should be going. Bail reform, it is of course something which has been with us for a while. Same story. Can our judicial officers with due respect, enforce, read, and interpret the law as it is? They're empowered, they have the discretionary powers to grant bail. Look through what is it that actually this person has failed to do. Okay, can't you probably think of ways and devise ways and means of enforcing his appearance so that he comes back? But at the end of the day, the person should be released. Let him continue with his life. First of all, we don't know when the trial will start. We don't know when it will end. You'll get a case which is so engaging and they bring in one witness after another. The witness we want, we are sorry is not available, is another court, is sick, he went for further studies. Name it, all sorts of excuses. You are in breach of Article 28, Clause 1 for crying aloud. Where is the speedy trial in this? Probably some school of thought has it that if there was a way of ensuring that speedy trial, then probably there would even be no use for bail. Someone knows I'm arrested, they've gathered the evidence, they are ready for trial. Yeah. And then I'll go and they prove their case or they fail and I'm acquitted. But now the challenge is you are like someone is suffering from all corners. Nothing is moving. The investigations are still going on. There is no bail. And the person is there. So we need to, I think, address our minds to this one and request other stakeholders to play their rightful role in this one. The other day we had the decision, a ruling, that the applicant has met all the requirements, but unfortunately we're going to decline. Now you wonder why. But the discretionary powers are there. You are clothed with these discretionary powers. Now, if you've come to the conclusion that the applicant has met, what is the big deal in releasing this person? Okay, I don't know. Probably they should be addressing us. That's why I'm saying that those engagements, why is it that they find it difficult to grant some of these remedies? They should come up clear and we know. Otherwise, this question of going to court, actually, I will tell you sincerely, I'm having second thoughts on whether I should be applying for bail. Looks like these days it's becoming something very unpredictable. You can never tell whether you'll get bail or not, or you'll apply and get bail on behalf of your client. So the other thing would be there is food dragging. As a judicial officer, you dismiss. If the prosecution finally is up to their game, they style up, they can shoot after all. It is a given. At that stage, one has not been acquitted. It's just probably being dismissed for want of prosecution. So I think we should be looking forward to such a day. Let our judicial officers be alive to these principles. As I said, let them breathe life into the constitutional provisions. Let them be bearing people. Otherwise, people are going to looking on and saying, now you lawyers, what is really going on? You quote the law, you cite the law, but nothing's being done. So I think our judicial officers owe us a lot of explanation on this one. You said something about the judicial review. I think we need to also to be very clear about that one. What is the judicial review we're looking at? The little I think I remember about that one. You are looking at bodies, probably bodies which have carried out quasi-judicial functions, and you are wondering whether it has been done in accordance with the law. So now it begs the question, does this need review? Does the judicial review need a review? What is it that they are doing? Are they doing things right? Same story. Is it stuck? Is it cast in stone that it, as it was, is now and ever shall be? What are the processes we are looking at? What are the parameters you are considering? Are they the same parameters? Are you looking at the illegality, the propriety? Is it reasonable? Etc. Okay, can't we think of other grounds? Because systems keep on evolving, institutions keep on evolving. Okay, why are we stuck in that? I think we should be alive. The jurisprudence is also building, the jurisprudence is also changing. So now, when you're talking of judicial review, should it remain as it was then? Okay, you are talking of time limits. I think, they talk of 3 months or something like that. It could be probably extended or whatever it is. What are the reasons? What are the parameters you're looking at? Why should you dismiss someone's application because he filed it beyond the 90 days or whatever it is? Okay. Can we still empower the courts who are doing the review with the more clothed with the more powers? They look at things in different lenses, aiming at better, aiming at making the judicial system function properly. I think the last one was on ADR. I think you mentioned about ADR. So I'm sorry, a good innovation. And what is it like? Is it still a pilot project? Is it something which should be given in all matters? You first of all go for ADR. I remember, I think Madame Christine Biraba was talking about it yesterday, saying that unfortunately, at times it is us, the council, who are frustrating, who are bogging down ADR. It may be true, because probably that is the bread someone's looking at. And if ADR takes full foothold. But I think she gave a good example, and I would be in full agreement with her. The few times I've handled civil matters, I'm one person who will gladly embrace mediation or ADR by whatever mechanism, because I know what it means. First of all, there's no guarantee when you'll have your matter handled and concluded. And there's no guarantee how it will end. A story is always told of someone who was handling a matter in court, and the counsel approached the client, said, "My friend, the defendant has gotten issues. The fellow is on his sick bed, and is considering paying you probably 3/4 of what is decreed amount, or even a half, or 60%. Why don't you take that and leave the rest?" I said, no. This fellow has made me suffer. He has to pay full amount. I said, "But can't you see the condition?" Unfortunately, the fella died. He went to meet his creator. And the same litigant came chasing the council. Council, what do we do now? Can't we now go against the administration, against the estate? I said, "No, man, what estate are you talking about? Do you know the fella's estate?" Okay, but now can't we? But you had promised to pay me. Can we go for that? But now, why? I told you, you should have taken that money. You saw the condition in which this fella was. So I think ADR, we still go down the same system. Is it still valid? Is it still applicable? Is it still serving the purposes for which it was intended? If there are any adjustments, let them be made. If they are not, then we can think of moving from ADR, then we think of a solution. Because at the end of the day, we owe it to the clients, we owe it to the litigants. They want a functioning system. They want something where they can go to. I think that's what colleagues were saying yesterday, where they know they receive justice, they receive remedies promptly, expeditiously. So whatever mechanism we can think about, let us look at the ultimate beneficiary, the litigant. So anything, even with PPP, I mean those prison, police prison pipeline, the bail reform, judicial review, ADR, I think we owe it to the people who serve. Like the constitution we've been referring to, it's made in the name of the people of Uganda. The short, the tall, the brown, the black, the Dinkas, the Vakonjo, whatever it is, name it. The people, are they? So we owe it to posterity, like I think Bwana Resida said. We owe it to posterity. So whatever it is, I think we need to be candid about this and express or bring out our views. And we're praying that, of course, the people who are touched, who are concerned, are on board and are alive to these insights. Otherwise, thank you very much. I think that's what I have to say for now. Thank you for listening to me.
Okay, thank you so much, Senior Counsel Kunya, and the same for Senior Counsel Resida Alec. We want to offer you virtual. Yes.
Yes, Robert. Sorry, I may interject. I just would like to ask people who would want to involve themselves in Q&A to ask for the microphone. It is their freedom to ask for mic, and then I will be able to approve it, and then they continue. Okay.
All right. Thank you so much, Adam, for that clarity that we were exactly going to delve into. We were offering virtual flowers to the two distinguished speakers who have broken it down beyond we could imagine. We want to thank you so much for the words of wisdom and the words of encouragement. We would like also to make sense of the time that we have. We had earlier on planned to start at 7 and end by 9. We don't want to go so far away from that. We would like to use the next opportunity, the next 20 minutes or they are about to ask questions. And to these panelists, these distinguished panelists, we have been requested by Adam to ask for the mic if it is well with you. We were also joined during the time of the call by the most perpendicular president of the Uganda Law Society, who has had an industrious day before this session. Mr. President, you are most welcome, and all the other distinguished guests as well who joined the call while we had begun. We take cognizance of your presence. We thank you for joining in as responsible citizens. Ladies and gentlemen, it is time for question and answer. We would like to, as we said earlier on, apologize for Madame Faith Odiambo's absence. We explained that earlier on. For those that are just joining, she had a plane to catch and wasn't in position to join us for a longer period of time. She was with us for the first 20 minutes or thereabout, 20 to 30 minutes. She sends her apologies. And the session has been taken on by these two very, very senior advocates in our spaces. We would like to move to the question and answer. The floor is now open. Please ask concise, evidence-based questions or share reflections. And as we focus on actionable solutions, practical ideas that strengthen accountability and protection of the vulnerable, and also aim to reclaim justice, like these two panelists have elucidated in very, very uncertain terms. If we can pick from a few of what you've said, you've spoken into the Constitution, breathing life into the Constitution, posterity, how can you be known to have done your part as a responsible citizen? Make a report, let it be there, even if it's for so long a time. Time and posterity will tell. But this is not the time, especially for that. We'd like to allow the general membership on the call to ask or share reflections as we will wait to hear from President in his closing remarks, as is always the case, who has blessed us with his presence, and then we shall find a way to conclude. Ladies and gentlemen, the floor is open.
Yes, Robert, invite Timothy Semaganda. Timothy Semaganda, you unmute and make your question short and precise.
Yes, good evening, colleagues. Good evening, senior colleagues on the call. Yeah, my question to them is, can you hear me?
Yes, Semaganda, you are very loud and clear.
Yes. So, senior colleagues on the call, what was the rule of law back? My question is, what was the rule of law then in the earlier regimes? Because I would like to have a picture of our conversation tonight.
Yes, Sema, if you can repeat your question, you were on and off, and I don't think maybe me I was able to hear you. I don't know, maybe others, but if you can rephrase your question, maybe for the sake of the good audio gathering.
Timothy, if you can hear. Your question, it wasn't clear to the general, kindly.
So sorry about that, but my question was, what was the rule of? Yes, I can hear you. Okay, sorry about that. So my question, what law in the earlier regime, so that we can have a context of our conversation tonight?
Thank you so much, Timothy. I don't know if we are on the same page. Your question seems to ask to ask into the state of the rule of law in earlier regimes in comparison to the current regime. And if that is the right question, if that's the position, we would like to pick it up from there. Your network was breaking, but we still have the speakers here. I don't mind any of them taking the mic if it's okay. Council Resida, if it is well with you, please take the mic and give us a brief, concise answer to that question. Thank you.
Thank you very much. That's a very, very broad question. What was the rule of law back then? There are many aspects of it that one can talk about. So I'll try to limit it to what we are discussing tonight. Prison, police to prison pipeline, who polices the prosecutors and so on. I'll pick it on two aspects. As a student, I did observe that the rule of law that time was probably at its lowest ebb. We are talking about the early 80s, mid 80s. The rule of law was at its lowest ebb, to the extent that even when it came to having the faith in the system to even file cases was lacking. There's no courage, there's no faith, there's no hope. Today, we have challenges in comparison to that. We have challenges, but we have hope. We have challenges, but we still seek redress from the courts and challenge them to live up to their calling. That wasn't possible. That was lacking. And what we must do most today is to do exactly what the late Njuba stood for and ensure that we don't go back to those days where we lose complete hope. And the trajectory can easily show you that you can end there. Always remember, when someone says you are hopeless, you actually feel abused. You really feel abused. But you know what? They are just two simple words. Hopeless simply means you do not have hope. And that's where the rule of law situation was. The worst we can have is to let it go there. There are many of us who are frustrated with the case backlog, inconsistencies in judgments, delayed justice, a lot to do with administration of justice, not application of the law, challenges of application of the law, manipulations of systems, and so on. We just need to be persistent and constantly address these challenges. And that's why when you have giants like the late Sam Njuba, we feel proud to honor him. I had a privilege of meeting him incidentally. He was a constant visitor to Jugan Company Advocates, not as a client, but for collegiality chats with the late Juga, and I benefited listening to his stories. He was a member of the CA, so the constitution we are talking about, and so on. By the way, his manuscript was confiscated from him by the Kenyan police in Kenya and later parts of it found its way to UK, and they tried to put it together and eventually published what they published. So the rule of law was at its lowest. The rule of law was lacking in hope, was lacking in reach, was lacking in being dynamic. And part of it was greatly impacted by limitations on freedom of speech. And whatever it is, whichever way we stand, whichever way we look at things, we have to acknowledge that freedom of speech in Uganda today is relatively much, much better than many countries in the region, than many countries out there. And it has enabled us to continue making a contribution to the betterment of our society, making a contribution to arresting the declines that we see. Having this space chat today, talking about excesses, talking about what to do about police, talking about what can be achieved, is a recognition of a better rule of law situation than was obtaining at that time. The levels of censorship, yes, still a challenge. The levels of arbitrary arrests, we are seeing them. But they are challenges, they are talked about. And of course, a lot has to do with changes in time. It's no longer easy in the world today to keep things wrapped up and unknown. And so you find that we take advantage of that environment to do what we can to ensure that, yes, Timothy, ensure that we don't go to that time of lack of hope, lack of faith at the lowest ebb possible. And what a better time than today when we pay tribute to the late Simon Juba. In maybe just a minute, let me pick up something in his memoirs. There's a very interesting line in there, and it goes, integrity and credibility are values one establishes without profit, popularities, or recognition. The position an individual holds in life oftentimes causes people to notice that individual. But only one's integrity will cause the people to respect that individual. It is those attributes that help to ensure that the rule of law continues, the selfless service of people with integrity. Thank you.
If I may, to supplement, thank you, Juan Alex Resida, for that. The same question about the rule of law, what it was, and I think he took it from about the early 80s or something like that. But some of us who were here a bit longer or much earlier, I have some sneak peek about what was happening in the Amin days, 71 to 79, because by the fall of Amin, I was, at least I remember, was in my S4. So now that tells you how far I've come. And I give glory to God for this fire has brought me. But to the point, during Amin's days, of course, you may have read, none of us probably has memories of who he was apart from the pictures and how he was doing his stuff. He was doing what was leading by decrees. He was the law. Okay, so there was nothing talk about parliament. There was nothing like the rules. He was the law. signing all those decrees in that period, 71 to 79. Okay. The other, as they say, is history, all those abductions, those arrests, and people disappearing without trace. And just, I think God was just merciful that we're able to pull through as a country, and we survived the aftermath. But like Mr. Resida said, it will be a great pity if what we are seeing or whatever it is or may come degenerates to what was there before. So there's that school of thought. Is it rule of law or rule by the law? Okay, I think there are two distinguishable features. We need to be very alive to this. It goes down to what I've been saying. The law has been put in place. We have a beautiful masterpiece in the name of a constitution for the people of Uganda. And like I read that before, the preamble, recalling the history, which was characterized by political and constitutional instability. I think every Ugandan should be alive to this. That is something, the benchmark against which the constitution was made, 1995. Recognizing the struggles against the forces of tyranny, oppression, and exploitation. Probably other things like the excesses, the name it, okay? Those issues to do with the impunity, probably they could have also been squeezed in there. But the point is, the Constitution was made with a view of building or coming up with a better Uganda for the present and for posterity. And I think it will be very unfortunate if we see, as they say, moving full cycle. It will be very, very unfortunate. So we need to really pray hard and ensure we do what we're supposed to be doing, and ensure that things are moving on, and we never go back. They called it the dark history, the bad days. And like they always say, let us make it possible, plausible for people to enjoy being who they are, being Ugandans in their space, wherever they are, whatever they're doing it in accordance with what is there, what is provided for, and everyone is happy. After all, the Uganda is, none of us is going to outlive Uganda. Uganda is, we found it here, we are going to leave it here, and so be it. So anyone, whoever anyone is, I think that should be the message. It is for all of us. How do we make a better Uganda? Okay, there are stories of Uganda Chinyuma. Can we change that narrative to Uganda Nyuma? Uganda Chinyuma. I think it speaks of so many things. So I think it's just incumbent upon us, upon whoever people, wherever they, whichever space they occupy, whatever opportunity, whichever powers they have, put the powers to good use. Use the powers, don't abuse the powers. Thank you.
So, thank you so much for those authentic and unfiltered comments and answers to the question from Timothy. We would like to move further. As Mr. Semwemba, you should be a speaker because you have a question. If you are, please shoot.
Good evening, honorable members of the noble profession, ladies and gentlemen, and to our seniors, thank you for your insights on this space. Mine is not a question, but it's more like a practical idea. Yes, as the bar, or as advocates, we hold the duty to hold to fidelity the Constitution. Because yes, we have all these ideas, we have everything that's...
Robert, have we lost you?
No, Adam, we're here. Simon is speaking. Please proceed.
And yes, Semwemba confirm that you are speaking to us.
Yes,
He
I am,
is.
sir.
He is.
So you,
Yes, we can hear him very well.
We can hear him.
and so
Please
you find
proceed.
that we've been left at a space of lamenting and filled with frustration. But then we should ask ourselves, how best can we empower the judges to stand to the law and keep the law? Because yes, we might have all these, we have to keep the Constitution, we have to guard the Constitution, but then we have to go to the same judges to do constitutional interpretation. But the very same judges that would probably interpret, write the constitution, they probably are not, they also they are in fear. How best can we empower them to know that actually their call is actually to serve justice? Today we find that habeas corpuses are just are not even respected at all. Judges just make decisions that actually contrary to the constitution. How best can we get to empower them to know that actually they are called to actually deliver justice? Be it as it may, to these judges that we have and the justices and the DPP, do they even get time to go to the prisons and see the congestion that is actually in those prisons? Because yes, it is one thing for us to say yes, we want to see changes, but how best can we engage them? Because I believe that there are certain sober judges that are actually on the bench that actually would want to see justice delivered. But in the midst of those judges, when probably they're persecuted, where are we as the bar, as advocates, to stand with them when they're being persecuted, probably when they have made decisions? And probably you can look at an example. We had very good judges that were in the High Court Criminal Division, but all of them were turned away, and some of them actually now in the Family Division. Where are we as the bar when such times come and the bench, some of the people that probably have a sane, sober mind, come up and they're delivering justice, and because of their decisions, they're just turned and taken to other circuits? So as the bar, how can we empower the judges to see that actually when their independence is upheld, that we support them? Because today you realize that even the judges themselves, some of them, they're sane and sober, that they want to deliver justice. But in times when probably they're persecuted, where are we to come and stand with them to see that we empower more of them? A clear example, you realize that we have one man that should probably have been a Chief Justice, Justice Engonda Ntende. But for years, even some that have actually came before him have actually went up the ladder than before him. So as the bar, how best can we empower these judges to see that actually they deliver justice and they feel that they have the independence amidst all the whatever is going on, but also inform them that actually it's the Constitution that is our shield, all of us, regardless of our age, regardless of our tribe, and regardless of where we come from. Thank you so much.
Thank you so much, Mr. Semwemba, for that very curious comment and very, very direct. We thank you so much for that. Of course, you have so many senior advocates on this forum who are listening in, but you see that's exactly the reason for this space in honor of the late Samuel Juba. We, as the need to bridge that gap between the senior counsel or the senior advocates and the young lawyers who are the majority in practice nowadays. And we want to ask these questions. We want to, bang the table. What has not been heard of before is what exactly we are trying to do. And we want to thank you so much for that observation. It is something that we take in stride, and would like to use this opportunity as we celebrate or commemorate the Rule of Law Week, and in honor of Senior Counsel, use this to relate. We thank you so much. We would like to note that we were joined by, if just by the way or the Twitter handle, the uniform that is giving by Afande Andrew K. Mubiru, who is the Acting Director of Forensic Services at Uganda Police Force, who I am very sure many of us have either interacted with or heard of. I think the only police officer who is on this call, and who, of course, earlier on we intimated we had written to by way of formal invite to take a position and also take the microphone, but we did not get any response. But that he is here, I would like to break a little of the rules, and if it is well with him, give us very, very few comments, if it's okay, about the topic at hand, which I want to believe he has been following. Adam, if you're there with us, could you please pass the microphone to Afande to just hear his voice and also share his views. Of course, it's not in relation to what the spokesperson should have said, but if it's well, Afande Andrew, are you able to speak to us? Adam, are you there, please? Could you please activate Afande Andrew's microphone? Adam?
Yes, yes, Afande Andrew, I've sent him a mic request and I await him to approve it. Afande Andrew, you check for the mic request, or you can send me a mic request through your bottom left. There is a microphone icon there.
Thank you very much. Sorry, I may not be able to speak to great lengths to the topic. As I've been introduced, I'm Andrew Mobiru. I'm Director of Forensic Services, Uganda Police. I'm happy to listen in to the contributions by members, but I may not be able to respond in full since I've just come online and I was trying to get my orientation around the topic and what the contribution is. But I'm excited to listen and I will be responding to anything that may arise. Thank you.
Thank you very much, Afande.
Are there Q&A for him? If there is any question for him, it can be forwarded. Thank you.
Yes, like we said, thank you, Afande. We are in. You, of course, have come in a time when we are not so far away from closure. We were just about to listen in to the president of the Uganda Law Society who has joined us. I would like to request Adam also to activate his microphone. And in the meantime, if we have questions for Afande Andrew, because of course the topic has been touching one of the government agencies or departments, which is the Uganda Police. And like we said, we earlier on sent a formal invitation to this forum, which was not responded to. We cannot point a finger, but you taking time to join us also means a lot. It shows your interest, and we would like now to use this as a question and answer session. If there is any question that our members have for the police, but the general feeling, which Afande, I know you also being a Ugandan are aware of. There is, of course, a lot to be desired with the Uganda police. There is a lot to be desired with the prisons, the government agencies that are in charge of law and order. And there's just too much that has been said by these senior panelists of ours on the call. The abuse of power, in which we have had scenarios like Council Resida cited a case of a colleague, Council Kagwa, who of course was mishandled even in his practice, which is not something new to very many of the lawyers. I believe you've also experienced, whether not necessarily personally, but you've heard of, and scenarios that are despicable, while advocates are, of course, also practicing what is preached in the IBS standards that are global. Like Councillor Resida said, we've been disappointed in how the police handles practicing advocates. The police handles files. The police is just in the middle of everything because, of course, you are in charge of law and order. So we would like to wonder. The reforms that are always spoken about, the reforms that are always passed, the comments that the advocates leave behind, the rules, the laws that are passed by Parliament. We have said to have one of the best constitutions in the world, but a lot is tired in its practice. The issues of bail, the issues that are never resolved, the issues of backlog. Many a time are simply because the police is just not holding a file. Somebody is on remand or somebody's file is still being investigated. The 48-hour rule is not being respected. Just so much. This is a general comment. Of course, it's touching very many different aspects of the justice system, the criminal justice system. Would like to hear how better can the police be, because we are supposed to be you want to say colleagues in the justice law and order sector. We are supposed to be working on the same page, but we are found to be on the other side of the law just because we are calling the police out. Human rights abuses are enormous. They're not acceptable. But even when you report, there's orders from above. The police is Council Kunya has cited that very big elephant in the room, orders from above, which just shows that it is really no longer about the law. It's about serving the interests of individuals. Where do you stand? What is your position in this? Thank you.
Yeah, thank you very much for that. Maybe I will start with the last point where you mentioned the issue. I think this is something that we have completely demystified. The Uganda Police Force is part of the administration of justice chain. We are a law enforcement agency for all Ugandans and to secure life and property. But what is important to note is that the issue of orders from above has completely been demystified, and all officers are told that there is nothing like orders from above. We have what we call lawful orders. They are lawful orders, and indeed we follow these the orders which are lawful, and we follow the constitution and the laws of the land. When it comes to making arrests, when it comes to presenting people to answer for particular cases, the law is followed. And recently, I think you have had a PRO still mentioning this. We do make the arrests. However, in these operational environments, you will appreciate that there are a lot of things that go on. There are a lot of emotions that are usually vented out. And you should appreciate that the policemen are also human beings, just like every other human being. We have seen scenarios whereby somebody is being called in to answer for particular issues, or maybe being confronted by a police officer, but there is a lot of verbal exchange. And there are times when this verbal exchange goes a little bit too far. And sometimes the police officer is compelled to put an extra pressure on it. Albeit sometimes maybe others may go overboard, depending on the different temperaments that they are. I don't know if you saw the scenario that happened in the US where the deputy, I think, is it a deputy, is it the attorney general was arrested? There was somebody, a senior officer, was arrested by the police officer simply because they were being denied entry into a restaurant, but it escalated very quickly. And you could see how the police had to take measures to have them arrested and put on handcuffs. So we are trying to make sure that every police officer is trained on the elements of the human rights, the human rights-based approach to policing and everything. These are things that we train every police officer, and we are actually trying to institutionalize this particular training to make sure that everybody appreciates the human rights-based approach. But we also are cognizant that the circumstances on the ground may quickly change. It may not be the way that we would have envisioned that, everything will be calm, somebody will act rationally, but there are times when other situations will call for an irrational approach by some people. Not that it is intended, but it's just that it is a reaction to what is being faced. And these are things that we continue being educated about and trying to deal with. Now, on the issues of backlog and the like, one of the elements that we have been trying to address as the police, you have had the director CIB many times mentioning our efforts to transform our processes, to re-educate our detectives and all the other actors. But not only that, but also to retool the detectives and all the other actors, be it crime scene officers and everybody, in terms of making sure that we have a systematic approach to how we do this work. Key among this is the issue of digital transformation. The president of the Law Society, when he had just come in, he mentioned something to do with digitization and making sure that the bar is also digitized, and now the courts have already got the ICMIS. DPP is also working towards a digital arrangement. It's important that we see how we can complete the digitalization cycle. Prisons is moving ahead. The police is still in the early stages of our scoping. And this is where we need to go. Of course, most of these things require some resources. Appreciate that the backlog sometimes comes as a result of the type of cases that we ingest into the system. There are some cases that we may need to rethink on how they are handled within the criminal justice system, especially if we can figure out how to have them diverted to other areas. For example, if we could think about maybe civil cases which are brought to the police. There are so many civil cases that we necessarily are not within the police ambit, but people find it easier to just come to the police for everything. So sometimes this creates also some bit of a jam in the system. And then all of a sudden we have these other high intensity criminal cases that we need to deal with. And then the resources have been diverted to deal with other civil matters. But for the cases that we have within the criminal justice system that we must deal with, these are cases that we are focusing on, but we also are trying to make sure that we have a streamlined approach and a coordination with our fellow stakeholders. We now have the DPP whenever we do cost conferencing, so that we really see how quickly do we bring certain matters to bear, and then also passing it off to the courts of adjudication. Now, of course, when these matters come up to court, the court has to cause list these cases at their own time. The courts of judicature are independent in nature, so we have to wait on them to cause list these matters, and then we have to bring these matters to court in terms of the evidential material. But I appreciate that crime has changed greatly. Everything now has gone digital. We now have more criminals in the digital space than in the physical space. So our tools need to be upgraded. So there's a lot to think about in terms of this space, and we need a lot of help in terms of the discussions in this space. We are having this discussion together with colleagues, as they're mentioning. We are hearing you, we are taking note, but we also need to change a few things here and there moving forward. But it's not all gloom and bad. There are some efforts. The government has already supported us in one way or the other to catch up with the current trend of crime using the anti-crime infrastructure. But quickly, we need to upgrade it also to catch up with the latest trends that we are looking at. And also the cross-border crime that we are seeing. Somebody commits an offense this side and then runs off to the other side. There's a lot of things that we are grappling with. But we hear you. We do appreciate the concerns that are raised. We are doing our utmost best to ensure that everything that is mandated to us as the police is done as per the law. There could be some shortcomings, but they are not intentional and they are not institutional. And in any case, the law has to be followed, and we ensure that that all is done in the interest of the nation and the public at large. Thank you.
Thank you so much, Apande. This is very, very welcome. Thank you for the gesture of both attending and taking time to answer us in spite of your coming in slightly later than we had begun. And of course, like we said, not want to take so much of the time of the members. The points have been noted. We appreciate your concern, and we shall also borrow from maybe what you missed as compared to the previous regimes. One of the panelists has painted a picture of hope, because then there was hopelessness. So the efforts that the government is undertaking are welcome, but like you also alluded, there is just yet a lot to be desired, and we shall not use this opportunity to get into the details because of time, and being that it's already getting later than usual. We would like to encourage that these spaces are welcome by the police and the government agencies, because these are really about the government agencies, the membership, the population is giving feedback, and it's only right that you were able to respond. I will not. I said we're not pointing fingers to you. Generally, you know that we are very, very, very anxious to listen in from government agencies, because this is really about you. So when you don't come in like this, it becomes a challenge for us to discuss a seemingly one-sided issue. But yeah, thank you so much for your additions, your comments, and we shall listen in as time goes by. As we commemorate the Rule of Law Week, we are still going to be having more discussions of this nature. We would like to request that you always keep in touch with the Radical Nuba, which, as you said, is already ahead of the game in as far as digital transformation is concerned, and we only welcome other institutions to follow suit. Ladies and gentlemen, we would like to listen in from the president of the Uganda Law Society, who has been made speaker, and without very uncertain terms, we'd like to welcome him to give us his remarks. As we see to it that this space comes to an end, we would like to, we take note that Clever has been made a speaker. Let's kindly listen in to the president of the Uganda Law Society and see how the discussion can be put to rest. Thank you, Mr. President. You are welcome to the space.
Thank you very much, Robert. Please confirm that I am audible.
Mr. President, you're very loud.
We can hear you.
Thank you very much. I would like to thank our panelists who showed up, led by Senior Counsel Alex Resida and Henry Cunha. And I would like to reiterate apologies for my counterpart, Faith Odiambo. She really desired to participate in this conversation and give us the cross-border experience from Kenya on this issue. But the competing duty schedules failed this effort. But we will have to compensate on this matter, because what we are going through, the transition we are going through, they have experienced it and they have resolved it in ways that we can learn from. For instance, they thought that they could create IPOA, that's what they call it, the Independent Police Authority, way back in 2010, I think, to coincide with the Constitution. So they have 15 years of the IPOA experience. Has IPOA managed to bail the cat, or they are back to square one? Unfortunately, we missed that conversation, but we promise we will be back on that issue. In Kenya, again, we saw the country go through two important moments of accountability for the police leadership. Contempt of court charges brought against the IGP.